For today, Mr. Marty.
This name of this contract does not refer nor identify the male standing in this corporation. I, Jamil Marty, being forced to go against my will and my best interest. My right of due process have been impeded upon saying I don't understand.
Mr. Marty, what are you asking me today? I'm gonna give you one.
I don't need him on my case.
Okay, are you at, listen, what are you asking me to do?
Or this one right here. This one, both them two right there. I got some that's conspiracy on what they trying to do.
Okay, what do you want me to do? When you said before you didn't understand that, you were not being truthful with the court. Is that correct?
I mean, I'm saying yes, sir, to say yes, sir. I'm guessing you agreeing with me. I don't know.
No, I'm asking you a question. So you don't understand that. Is that correct? So
I ain't trying to make a fool of myself, but Your Honor, I don't need them two on my case.
Okay. You can barely read and write. Is that correct?
I learned.
You guys understand? What are you asking for today?
I'm asking to be appointed different counsel, Your Honor.
Okay. And what are your grounds?
My grounds is, Your Honor, Ms. McCarthy, she's very incompetent. I request to discharge the counsel appointed substitute. Even Ms. McCarthy on this case, Your Honor, it will result in ineffective assistance, Your Honor. She has not provided me adequate counsel whatsoever.
In today's Judge Clarke double feature, two pro se defendants are determined to fire their court-appointed attorneys and go at it alone. First, we are met with a SovCits defendant facing the terrifying possibility of not one, but 2 life sentences. Despite being self-admittedly illiterate, this stubborn defendant is absolutely adamant about representing himself. Will Judge Clarke allow this ill-prepared SovCit to go pro se in such a serious case, or will the judge decide he's unable to represent himself and require legal counsel? And in the second case, we got another pro se defendant who feels his court-appointed attorney has failed him and is demanding either a new lawyer or the right to defend himself. Will he be able to convince Judge Clarke that his attorney is truly incompetent? Or will the judge stand behind the defense counsel and deny the request? Let's watch and see how both these pro se courtroom battles play out.
I know Mr. Salim represents either one of those.
Salim?
Mr. Salim, can you join us?
Your Honor, can I speak for the record too?
Williams, finish knowledge.
Yes, sir.
So I think we're set to go to trial on 1933-65 next week, and I presume 2756 as well.
Yes, Judge.
I know that we had a couple motions that we dealt with last week.
I didn't rule on the motion to consolidate.
You did, Judge. You granted it last week. I don't know that there's been a written order, but you granted it in court. I actually had filed a amended information consolidating those 2 counts, but I left it on the printer this morning, so I will file that. Okay. My intention is in the 1933-65 case, he is currently charged with 2 counts. One is the felon in possession of a firearm. That would have to be bifurcated anyways. So I had not included that in the amended information, and I plan on moving forward with the attempted first degree murder with a firearm and the tampering of the witness at trial next week.
Okay. And my recollection, Judge, was that you, at that hearing, I remember you saying that you were inclined to grant the joinder of them. I'm not sure. You may have said it.
But if I did and just to have an abundance of caution, I'll grant the motion.
And that was certainly, I anticipated you do that, and have been acting accordingly. I would like to put a few things on the record, Your Honor. My client had an offer from the state last week, and he did not wish to take advantage of that offer. My investigator and I went out to the jail, talked to him, went over things, explained everything to him. I gave him my advice, which was that I thought it was in his best interest to accept the offer. He refused that, and that offer was for 20 years with a mandatory minimum. He still has an offer today for 25 years mandatory minimum, and I've discussed it with him briefly over here in the box, and he's told me that he doesn't wish to do that, but considering the fact—
Your Honor, this man ain't even helped me in my defense. None of that.
Mr. McCarty, I told you I'd give you an opportunity to speak.
Okay. Yes, sir. Yes, sir.
Finish.
What I was going to say, Your Honor, is considering, I've explained to him that his exposure is in the 3365, the attempted murder case is a life sentence, in that he's further exposed in the 2756 case on the tampering to an additional 30 years, since it was a tampering with the underlying case being a first degree. So I've explained to him his exposure. I've given him my advice. I've told him what I think is best for him. And he, as is his right, he's choosing not to do that. But I did want that on the record so that there was no confusion later on about whether or not I had informed him of the offers and how I advised him and that sort of thing. So,
Your Honor, my intention is to revoke those offers today, and I plan on moving forward next week. One thing that Mr. Williams mentioned, yesterday I filed the HBFO notice, which actually extends his exposure in the tampering case from 30 years to possible life in that case as well. Okay. So the maximum that Mr. Cromartie faces is 2 life sentences consecutive.
Okay. I really wasn't aware of that. You hear what he said?
Yes, sir. But
So let me ask you this. Before the judge is going to give you a chance to talk.
Okay.
But in light of the fact that Mr. Sullivan has made this new filing, and now you have your maximum exposure is 2 life sentences, do you wish to reconsider your choices with
I don't
regard to
understand.
accepting the offer?
I don't understand. I don't understand. And being that he's representing me, we haven't even worked the defense in this case at all, period.
Okay.
And plus,
Let's take one thing. Do you understand that you've been offered 25 years in prison?
I don't understand, sir. Yeah.
Then yes, you do understand you have a plea offer of 25 years in prison.
I don't understand because I'm innocent. I don't know what's going on.
Listen, you've entered a not guilty plea, so there's a presumption that you're innocent, or a presumption you're not guilty. So that, regardless of your claims or the fact that right now we presume you not guilty, you understand the state has offered to let you plead no contest to charges, and it'd be a 25-year sentence. And I believe, what is it? Is it a minimum mandatory 25?
It would be a minimum
Mandatory minus the time you served in jail. No, I just need you understand that's the plea offer from the state.
Hell no. I don't understand none of this, what he thought. And it's a conspiracy between these two.
Listen, Mr. Cromartie, what do you?
Man, I don't understand, sir. And
I don't believe you, Mr. Cromartie, because you act like you do understand it. But what are you asking for right now? What are you asking for?
I'm asking for him to be removed off my case.
Raise your right hand to be sworn.
I do.
Wait till the oath is done, sir. Do it again, madam.
Yes, sir.
Raise your hand again.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but it.
Yes, ma'am.
All right, Mr. Cromartie, state your name.
Ismail Cromartie.
What are you asking for today, Mr. Cromartie?
This name of this contract does not refer nor identify the male standing in this corporation. I, Jamil Cromartie, being forced to go against my will and my best interest. My right of due process have been impeded upon. Also, my 4th and 5th Amendment right have been violated. I invoke my rights of the Constitution to protect me and my best interest. I invoke my 5th Amendment.
Okay. All right, then you vote the Fifth Amendment right, so you're not asking to testify. What are you asking me to do?
First of all, I have the right to face my accuser.
Listen. What are you asking me to do today, Mr.
You
Cromartie?
saying I don't understand.
Mr. Cromartie, what are you asking me today? I'm gonna give you one.
I don't need him on my case.
Okay, listen, what are you asking me to do?
Or this one right here. This both them two right there. I got some that's conspiracy on what they trying to do.
Okay, what do you want me to do?
Continue my trial.
No, sir. Motion denied. What are you asking me to do? What are you asking me to do, Mr. Cromartie?
A fair trial.
All right, right now you're gonna get a fair trial. Is there anything you're asking me to do right now?
I'm saying I don't need them on my case.
What are you asking me to remove them?
Yes, sir.
And then are you gonna represent yourself, or are you gonna hire another attorney?
I'd rather represent myself to be the attorney.
You already sworn in, so state your name again.
Jamil Cromartie, sir.
Mr. Cromartie, you're asking to represent yourself next week. Is that correct?
Yes, sir.
Okay, you understand that you're looking at life in prison if convicted of two life sentences.
Okay.
You understand that?
Yes, sir.
Okay. Do you understand you've been offered a 25-year plea deal?
Yes, sir.
And when you said before you didn't understand that, you were not being truthful with the court. Is that correct?
I mean, I'm saying yes, sir, to say yes, sir. I'm guessing you agreeing with me. I don't know.
No, I'm asking you a question. So you don't understand that. Is that correct?
Understand what?
That you have been offered 25 years in prison if you pled no contest and that would settle your cases. Do you understand that?
I don't know how to answer that.
You're going to have to answer my questions if you want to represent yourself, sir. If not, I'm not going to find you competent to represent yourself.
Yes, sir.
Do you understand you've been offered 25 years in prison? Is that correct?
Yes, sir.
Okay. So when you said before you didn't understand that you were not being truthful with the court, is that
It's a lot that's going on that I don't understand.
Listen to me.
Yes, sir.
You were not being truthful with the court. Is that correct?
I'm not gonna say I'm being truthful.
When you
I
said-
don't understand.
You don't understand.
You got to talk to me in a level where I got to
Yes, sir.
understand.
I'm talking to you the same level.
But some of it I don't understand because there's some shit.
So you
that's
don't
going on.
you don't understand what's going on?
Half of it I don't.
Sovereign citizens often refuse to admit that they understand anything because they take the word understand literally, interpreting it to mean stand under or be subordinate to someone or something. This tactic is part of a broader strategy to reject the court's jurisdiction. Sovereign citizens often engage in various linguistic tricks in an attempt to avoid acknowledging the court's authority over them. By refusing to say they understand, they believe they are avoiding any admission that could be construed as accepting the court's power.
How far did you get in school?
9th grade.
And you read and write?
Barely. I could barely spell.
Okay. And do you understand if you represented yourself, you'd have to do everything a lawyer
I'm gonna
did?
do what I can that I've been trying to do.
Do you understand you'd have to do
I
everything?
do better than him.
Listen to me. If you want to represent yourself, you got to answer these questions. If not, I can't allow you to represent yourself. So,
I ain't trying to make a fool of myself, but Yana, I don't need them two on my case.
okay. You can barely read and write. Is that correct?
I learned.
You're going to pick a jury Monday morning. I'm not continuing the case. And you're going to try the case next week if you represent yourself.
Okay.
And you read and write.
I'm gonna learn.
You don't have time to learn. So you can barely read and write. Is that correct? You don't understand about the plea offer. Do you understand that lawyers are trained in the rules of evidence, criminal procedure, and the law. They're there to assist you in preparing for trial and trying the case. Do you understand that? Okay, well, I'm going to find that you're not competent to represent yourself. Mr. Salim will stay on his case. Mr. Williams will stay on that case, and we'll see you Monday morning and pick a jury.
All right.
A motion for a Nelson hearing.
Right, and Mr. Stanley, would you like to go forward with that?
Yes, sir, I will, Your Honor.
All right, if you'll swear Mr. Stanley in.
Testimony you're about to give is true.
Yes, ma'am.
All right, sir, state your name.
Xavier Javaris Stanley.
Mr. Stanley, what are you asking for today?
I'm asking to be appointed different counsel, Your Honor.
Okay, and what are your grounds?
My grounds is, Your Honor, Ms. McCarthy, she's very incompetent. I request to discharge the counsel appointed substitute. Even Ms. McCarthy on this case, Your Honor, it will result in ineffective assistance, Your Honor. She has not provided me adequate counsel whatsoever, Your Honor. I got a lot of grounds. Back in August of 2023, Ms. McCarthy told me that she reviewed the case, determined I would never should have been charged for this robbery, first and foremost, Your Honor. She also met with me November 16th, November 17th, and November 20th of 2023, and told me that I should not enlist the facts in the motion to dismiss. I had the counsel at the jail pull that too as well, to where she told me not to enlist my facts in the motion to dismiss, Your Honor. Let's see. As well as the sworn statements on both cases, Your Honor, we got evidence to where the victims in both situations excluding me. We got one victim lying, giving two contradicting stories, Your Honor. Ms. McCarthy advised me that she would have these charges dismissed due to the police bribing witnesses to implicate me in this situation, Your Honor. That has not been done. She said it doesn't matter the facts because you believe every defendant is guilty until proven innocent. Her words, I got that too right here for you. It's in a letter, if I may approach. The second page is for you. I highlighted it for you. I know all you gotta do is read it.
Got a copy to the state. Let the state look at it.
I got one for him too, Your Honor, if you need it.
Yeah, you need, if you're going to Well, if you're asking to accept that in the evidence, you can just let the.
Just highlight what she said. I wasn't done though, Your Honor. I can continue if I may.
Go ahead, let me see it there.
Judge, with the uniqueness of these claims, Your Honor, that I make, it consists of that letter in the paragraph that you finna read that's highlighted, Your Honor. And as you can recollect, when I was here December 19th for the motion to dismiss, Your Honor, she said absolutely nothing. She stood where she is now. She ain't defend me whatsoever. She said not one word, Your Honor. Me and Mr. Sullivan went back and forth like I was representing her in the courtroom, Your Honor. You know what I mean? More so, Your Honor, if you notice in the letter, on paragraph, she said, I cannot think of a defense that would be successful in trial. I don't need an attorney like that who's incompetent, who does not want to list the facts in her motion, pertinent to the release sought in the motion, Your Honor, does not open her mouth in court proceedings or fight for the defendant whatsoever, Your Honor. She does not, Your Honor. And that's a 4-year-old letter from somebody else. This is what she continues to tell the clients, Your Honor, about you in this courtroom. She continues with the same defense, Your Honor. Ms. McCarthy was supposed to talk to the
record, what I just wrote was somebody from another client.
Somebody family mailed that to me, viral mail to the Bay County Jail, Your Honor. This is the same thing that she's
I'm not considering that.
It's cool.
That's what I was gonna ask about, Your
I'm
Honor.
gonna strike that from the record, and I'm not considering that, Mr. Stanley. What?
You throw it away. I don't know.
Just give it back to him. I'm not considering that. I'm not putting it in the file. That's a letter to somebody else.
Your Honor, if I may continue, you were supposed to talk.
I haven't heard anything yet, sir, but go ahead.
I'm telling you, you were supposed to talk to the investigators to interview this bribe witness that they used, the only witness that they used to try to implement me in a robbery. She didn't do that, Your Honor. I got the document with these different victims, Your Honor, where they gave 2 different sworn statements on the oath. She has done nothing to present that either to the prosecutor, Your Honor. It's in black and white, Your Honor. These are signed statements. These are sworn statements on the oath. Ms. McCarthy was supposed to get the photos to exclude me as this suspect in this robbery. She didn't do that, Your Honor. I was supposed to go over the victim statement with her to provide what let me see. Ms. McCarthy was supposed to go over the victim statement, which proved the perpetrator was a Hispanic and not me. She didn't do that, Your Honor. And this is all of my discovery. It's all sworn statements. And I done had this Ms. McCarthy since August, since May. It's been 8 months. And she's done absolutely nothing.
You testified that she had been to the jail to see you, is that correct?
She's been to see November 16th, November 17th, and November 20th. I had the case manager as well as classification pull that video. It's attorney-client.
She went to the jail all those days?
3 days. I'm
gonna let Ms. McCarthy respond at this time. Ms. McCarthy?
Your Honor, the reason that I went all those 3 days is because we were doing a motion to dismiss, and Mr. Stanley wasn't happy with it, and so I kept coming back with it until he decided to sign it.
Because you told me not to put the motion to dismiss the facts.
I'm striking all that. Let her talk. If you say anything else, I'll allow you. Don't say anything else while she's talking.
The motion to dismiss was the motion to dismiss. It stated all the facts that would be pertinent to dismissing the case. The reason that I didn't argue when we got to court is because a traverse was filed and there was nothing else to argue about. And that's where we are. We're ready to go to trial.
All right. Mr. Stanley, I haven't heard anything that Ms. McCarthy has done that would, that has not been, in your best interest or in preparing for your case. If the state filed a traverse, there's nothing to argue about. No, that's it. I've ruled. I'm going to deny your motion. We need to set him for trial.
I believe it's set for trial.
How are you denying? I'm telling you, she's done absolutely nothing, Your Honor.
Just denied it. That concludes the hearing.
And I got a video in the county jail to where she said not to put the facts in my motion. I already had them pulled at the jailhouse. They shouldn't be, they shouldn't be, Ms. McCarthy may need to look in that. If they've got something, they're filming attorney-client. She perjured herself in your courtroom sitting here lying.
That will conclude the hearing, sir. We already set for trial.
I believe we are.
All right, leave it on the trial docket. Don't say another word, sir. Go ahead and take him back in the back before he gets in trouble.
All comments, viewpoints, interpretations, and insights expressed in this video are for education and entertainment purposes. All individuals featured in the video are to be presumed innocent until proven guilty in a court of law. Please do not attempt to contact, locate, or engage with any individuals featured in the video.